on data protection and privacy law for that purpose. First, we have Orla Lynskey, who's Associate Professor at the Department of Law at the London School of Economics, and who is a graduate of the law school here in Trinity. Orla is going to talk to us today about the debate around contact tracing apps, with a focus on that debate in the UK context. Secondly, we have Maria Grazia Porcedda from the law school in Trinity. Maria Grazia is our assistant professor in IT law, and Maria Grazia is going to talk to us about some of the challenges closer to home, including as we start to phase out of lockdown. For those of you who, like me, are desperate for a haircut, some of what Maria Grazia is talking about today will be of interest to you. And finally, we have Colum Walsh, who's a Deputy Commissioner at the Data Protection Commission here in Dublin, where he's a head of regulatory activity. And Colum's going to share the perspective of the DPC on some of these important challenges. Each of the speakers will speak for around 12 to 15 minutes, and we'll hopefully have some time at the end for questions and answers. If you have questions, there's a Q&A function at the bottom of the screen. Feel free to write your questions as they arise, and we'll get to them at the end. Without further ado, I'm going to hand the floor over to Professor Orla Lynskey. Orla.
Brilliant. Thanks, David, and thanks for the opportunity to participate in this seminar. I'm afraid today I don't have any slides or things, as things are still even more chaotic than usual over here. But what I want to talk about today is the debate in the UK regarding the rollout of the proposed NHSX contact tracing app. So this was an app that was initially mentioned or kind of started to come into the public domain in about mid-March, with the government officially announcing that an app would be rolled out coming towards the end of, coming towards mid-April, so around the 12th of April or so. And then fairly soon afterwards, so around the 5th of May, the app was trialled on the Isle of Wight. And so during this period, there was intense debate within the UK about the legality of the app, and in particular, the respect for data governance in the way in which the app was rolled out. So ultimately this week we have found out that the app, the cherry on the cake of the government's contact tracing system, will not be deployed now until at least September. So this has been kind of kicked into the long grass. And the primary reason given for that is that it was failing to adequately identify proximity between Apple devices. But I think the app itself was also kind of plagued by various data governance issues, which I'll talk through today. So first of all, I'm just going to say a little bit about the proposed app from the information that was in the public domain. Then I'm going to highlight some of the legal issues that were really prominent in the public debate in kind of March, April. And then finally, I just want to maybe highlight some of the legal issues that I think still remain unaddressed, and maybe shed light on kind of broader data protection issues that we'll see kind of going into the future around COVID-19. So about the app itself, well, I think the first thing to say was that it was kind of shrouded in secrecy. So there wasn't very much known about the functionality of the app from a technical perspective, because initially none of the source code was made available. And so there wasn't very much kind of opportunity for scrutiny in these kind of early phases. However, we did know that the app would be based on self-reporting by individuals. So I think this was the first major difference between the UK and elsewhere. So rather than being based on test results that might be input by a medical professional, this was going to be based on individual self-reporting. And then a second key point was that the UK was opting for a so-called, I'm sorry, this is England in particular, was opting for a so-called centralized app, as opposed to the decentralized app, for instance, that's being proposed in Ireland. And the key difference between centralized and decentralized in this context is that with the centralized app, when an individual self-diagnosed as or self-reported that they had COVID-19 symptoms, their identifier from their phone, as well as the identifiers of other phones that they had been proximate to, and all of this data was collected via Bluetooth, all of those identifiers would then be updated to a centralized server. and the matching of the individual with other contacts would occur kind of at a centralized level. Whereas with the decentralized app, this matching occurs on an individual's phone. So really that was the kind of key technological difference between the two systems proposed. But maybe a third feature to note was that from the outset, the NHSX and its CEO, Matthew Gould, had highlighted that there would be the possibility down the line for individuals to voluntarily add further data to the centralized database. And initially we were told this might be the first segment, for instance, of something like a postcode that could then be added to the data being collected at the centralized server. So immediately, I think the concerns that were raised before a joint human rights committee that held a kind of a parliamentary session on this were really kind of threefold. So there was concern about the fact that this was occurring at a kind of a centralized level, that we would be creating a centralized database as opposed to something decentralized. And some very prominent lawyers in the UK, Matthew Ryder, QC and others, described this as a significant and unprecedented step in the government's surveillance of the public. Because by definition, the holding of that central database by the government would enable, or could enable, for a kind of function creep. And you couldn't be sure that data collected and stored for one purpose would not down the line be repurposed for other reasons. And of course, there could be very valid reasons to repurpose this data. You might think, for instance, of research. However, in the UK at the time, there was quite a lot of discussion about the integration of tech firms with questionable reputations when it comes to personal data processing, like Palantir, that were kind of being embedded in the NHS system, and a query about who would gain access to this type of data for research purposes. So centralization per se was looked at as potentially problematic, not necessarily always prohibited, but something at least that begged questions. The potential for function creep was highlighted. There were issues highlighted around data accuracy. If individuals were self-reporting their kind of symptoms and then diagnosis, because you might, for instance, think of a scenario where a teenager or any of us don't want to go to work. We self-report that we've got COVID-19, and that might kind of demobilize an entire segment of the economy at any given time, or a get out of school free card at the minimum. And there was and so here there was a bit of an odd kind of circular justification given by NHSX that the centralized database needed to be in place in order to identify kind of fraudulent behavior in this way. But I think at its roots, this kind of really comes back to a question of the testing capability that was in place in the UK at that point in time. And so you had function creep, you had issues of data accuracy, but also because you had this possibility at a later stage to add data to the database, this raised the possibility that the database itself could be used to not simply identify an individual who has COVID and their contacts, but also to geographically locate those people. Because if one person updates their geographic location to the database, that would inadvertently identify the geographic location of others. So you create a kind of a social graph of people's contacts, but also, and contrary to the advice of the European Data Protection Board, which said that contact tracing apps should be about mapping proximity rather than location, you had the very definite possibility here that the app would be used to reveal location as well as proximity. So all of these issues, I think, raised queries. None of them were kind of per se illegal, but what this did kind of reveal was that we had very kind of scant detail about how the app would function in practice. And this in itself, I think, raised a serious data governance issue, which was that at the time of the hearings before Parliament, and so 5 days before the rollout of the app on the Isle of Wight, the Information Commissioner in the UK, the regulator, the data protection regulator, had not yet had sight of a data protection impact assessment. And clearly here, I would argue at least that under Article 35 of the GDPR, you would need in this type of circumstance, given the sensitivity of the data that we're talking about, and given the fact that this would be rolled out on a national basis, you would need to conduct a data protection impact assessment. So before the Parliamentary Committee, the Information Commissioners suggested that they were working in kind of close cooperation with NHSX, but did indicate that they hadn't yet had sight of the DPIA. And a further issue could be that I think you could make the argument at least that there was an obligation of prior consultation by NHS to the ICO in this context, based on Article 36 of the GDPR, which states that if an entity, a data controller, is going to be engaged in high-risk data processing, and if it is not possible to mitigate all of the risks through legal or technological safeguards, then that prior consultation should take place. But that didn't occur. And so what we saw was the rollout of the app on the Isle of Wight, with many data protection and data governance issues still unaddressed. And just one last point, at that early stage, was that the Parliamentary Committee concluded in its report that legislation would be necessary in order to kind of drill down into how specific data protection principles, such as purpose limitation, what purposes does the app serve, and does it, could the data possibly be used for incompatible purposes? Purpose limitation, data minimization, the storage limitation period. So for instance, initially the DPIA for manual contract tracing in the UK suggested that the data would be held for 20 years, which is kind of clearly disproportionate to the length of time that you could argue is necessary for public health purposes. And the DPIA for the contact tracing app was itself silent on the storage limitation period. So the Parliamentary Committee, this joint Parliamentary Committee, argued that legislation was necessary in order to address all of these issues, and the government very strenuously rejected that call. So that, I think, was the kind of status quo. Last thing I want to say is, some of the big issues that I think this then kind of casts some queries over, or raises some questions about is, first of all, some have argued that data protection law driving the design of the app is kind of putting the cart before the horse, that we need to think first what is most effective from a medical perspective, and then, how can we ensure data protection compliance? And, to a certain extent, I would agree that data protection law has that inherent flexibility to allow that to happen. But a lot here depends on how we interpret the concept of necessity in data protection law. Because, if you look at the legal justifications, the legal basis for processing sensitive data, you see that you can process sensitive personal data when it is, for instance, necessary for reasons of substantial public interest, or necessary for the purposes of preventive or occupational medicine. But how do we interpret necessity? And here, I think this is going to be interesting in the UK in the future, because first of all, we have some Court of Justice case law, Huber, where the court says, well, necessity simply means that legislation should be kind of effectively applied. So that's not a particularly stringent standard of necessity. You have ECHR case law kind of saying necessity means it should be something less than indispensable and somewhere kind of more than useful. But then we also have case law from the Court of Justice with regard to the EU Charter, where the definition or the interpretation of necessity is incredibly strict, where it's literally described as a test of strict necessity. And so I think there is a query here about how necessity will be interpreted in this context. And again, in a world where the UK is no longer signed up to the EU Charter, whether it will go for a lower standard of necessity. And similarly, when it comes to the legal basis, for many contact tracing apps across Europe, we're reliant on Article 9 of the GDPR, so obviously around sensitive personal data, but most states are kind of reliant on Article 9(2)(g) or H, which are the specific legal basis for medical data processing. However, the argument has been made in the UK that because the app is voluntary, you could rather rely on consent in order to engage in data processing via the app. And again, if you remove the EU Charter from the picture for the UK in the future, some have argued that because the data processing in the context of something voluntary like an app is based on consent, then there is no violation of the right to respect for private life at all. So you no longer have a right to data protection because the EU Charter is gone, and you no longer have the protection of the ECHR because they say, well, there's no interference with the right to respect for private life. So this, I think, is also an interesting question in the UK that is yet to be addressed. And then finally, there was no resolution to this question of whether or not additional legislation is required. So, as I said, the Parliamentary Committee indicated that it was insufficient in this context to rely on government assurances about the data governance standards that would be in place. And myself and many other academics in the UK argued that it might even be necessary, there might even be elements of a contact tracing app that are not captured by data protection law. And you could think here of situations, for instance, in an employment context, where an employer might make it compulsory for an employee to simply show them their app every morning on the way into work. Now, in my opinion, the employer in that context would not be a data controller. They would be reliant on, somebody else's app, but in order to make decisions about an individual. And I think there's a query there about whether that type of conduct even falls within the material scope of data protection rules, and therefore whether you need additional legislative safeguards if you really want to prevent the compulsion around the use of an app in the private sector context, or at least to put safeguards in place for individuals if that occurs. I think I've probably used more than my time, so apologies.
Thanks very much, Orla. And we might come back at the end to the debate in Ireland, which for once has been a little bit calmer perhaps than the one in the UK. But your final comments lead us nicely into our second contribution. Maria Grazia, the floor is yours.
Thank you very much, David. I would like to ask whether you can see my screen.
Yes.
Okay, and now I've realized that, okay. Can you see my screen again?
Yes, we can.
Okay, wonderful. Well, thank you very much for having me today. Good afternoon to everyone. It's a shame we can't see each other, but at least we can do this. I'd like to thank, of course, the ISO, Professor Kavanagh, for inviting me today, and to give my take to the debate on data protection, pandemic and privacy. My talk is titled Under the Radar: The Dangers of Ordinary Data Processing in Easing Pandemic Lockdown. Because I would like to focus on some mundane mandatory data processing activities which are happening indeed under the radar. We are not really aware that they are ongoing at the moment, because the public debate is mainly focusing on tech-driven solutions. Before I continue, I'd also like to say that the research for this presentation is part of the COVID-19 Law and Human Rights Observatory, led by Professor Doyle in collaboration with Tricon's Professor Kavanagh. And I'd like to invite anyone who's interested in the topic to follow us and follow the debate that we are having through the observatory. But before focusing on the under the radar processing, I would like to start by actually praising the public debate that we've had on tech-driven solutions. Even though we don't have all of the answers yet, I think that we have been quite good, at least in this continent, to raise early concerns about what might happen as a result of the pandemic, many voices have cautioned against surveillance, including in Ireland with initiatives like the Principles for Legislators on the Implementation of New Technologies. And this early public debate has led to early guidance by the European Commission, the Data Protection Board, and the Data Protection Commissioner. And I don't think this is by chance, in the sense that data protection has gone through a long journey. Orla mentioned the fact that sadly it's no longer a right in the UK, whereas of course in the EU it's been fully recognized by the Charter and the Lisbon Treaty. Data protection started as a sort of obscure academic subject no one really knew much about, to a matter of public interest. As a result of the fact that our society is highly dependent on ICTs, of course, and because of the experience that we have accrued through a number of emergencies, whether that was data-driven responses to terrorism, or the NSA revelations, the Cambridge Analytica revelations, and so on and so forth. And we've sort of, thanks to the GDPR in particular, put together the necessary machinery to redress part, at least, of the power imbalance that this has caused. Now, there are opposing views, of course. There are some, particularly in the East, who believe that surveillance, extensive surveillance, actually led to curbing COVID-19 early. Only time will say whether that's the case or not. Of course, as a data protection passionate, I disagree, and I think that we may find that what helped curbing infections is located elsewhere. It may have to do with pollution, inequality, some even suggested the gender of the leader, and so on and so forth. What I think we need to remember is that whichever tech solution we talk about is part of a comprehensive public health strategy to fight the pandemic, without which we are heading nowhere. And certainly there are still things to be answered about tech-driven solutions as well. There's an ongoing debate, or perhaps this will spark a debate as to whether location data should be used more broadly than it can be. Maybe that will impact the regulation, the e-privacy regulation. Certainly there's a discussion to be had about the technology that we are relying on. No technology is perfect. Bluetooth is not perfect either. Additional reliance on technology also means making it easier for cyber criminals, for instance, to get their hands on our data. But the most important thing is that, as Orla was also discussing, that the app is still being tested. Apps are being tested in most European countries, and in some of them have not been launched yet. And this raises the question of, how many times they'll be downloaded, what's the minimum threshold, and so on and so forth. The point is that the apps are not necessarily there yet. So we're having an excellent debate about something which is obviously not happened yet, which needs a lot of debate, but it's not there yet. Whilst there are other forms of data processing that are happening as a result of COVID-19, and that have been happening in the height of the contagion, and to help easing the lockdown. And here I'm focusing on Ireland, of course. Different countries have taken different approaches. As of yesterday, for instance, in Ireland, people can enjoy a much broader variety of retailers than we were able to during the pandemic, and guidance has been to a great degree excellent, with various protocols released for returning safely to work, including specific guidance on data protection, which the Data Protection Commission also commented on by releasing additional guidance. So there's plenty to help those who are not data protection specialists to navigate the complex rules. So, for instance, those who want to go back to restaurants know that the person who is booking was doing the booking needs to provide his or her phone number and that this can be used for contact tracing should anyone become ill, and that these records can be kept for a month. There have also been other initiatives which may perhaps be a little bit on the side of overzealousness. The NSI released the Retail Protection Improvement Guide, which contains a questionnaire, which was readily adopted, for instance, by the Irish hair salons and barbershops. And this questionnaire helps collecting contact information, which of course will be helpful for contact tracing. However, it also comes with a second section that asks questions that not even GPs are currently asking people showing up at the GP practice, such as, are you experiencing any difficulty in breathing, shortness of breath? Are you experiencing any fever, temperature symptoms? Have you visited any other countries? How are you feeling health-wise? Some who have a web presence are asking people to fill in these forms online. Those who don't have a health presence are asking customers to download these forms and fill them in. And some have said very clearly that they cannot allow any clients in the salon without the form. Now, customers who are not quite familiar with data protection legislation may actually feel reassured by this sort of initiative, as it's probably showing that retailers are taking their health very seriously. However, this raises a number of questions from a data protection perspective, which is broadly to do with lawfulness and to a degree with necessity, in line with what Orla was discussing earlier. Well, from a data protection perspective, it's a bit of a nightmare. Of course, this is about personal data. Of course, whether this is being collected online or it's being downloaded and handed in, it will form part of a filing system, so it will fall within the remit of the GDPR. These forms come without information notice. There's no explanation as to why the data is being collected. Therefore, there's no discussion of the principles, but I mean, we are beyond that here. There's no indication of who is the data controller and who to turn to for data protection, to exercise one's data protection rights. And this is, of course, all the more worrying because we're talking about special categories of data. Arguably, this questionnaire taken together will provide information about health. There are other variations of this questionnaire circulating. I've come across one from a company that was a slightly better version of it. There were no information about who the data controller is and how to exercise one's rights, but there were at least indications of principles, not necessarily with a reference to the relevant data protection article, to the relevant GDPR articles, but there were still references there. And a bit of an explanation, including legal basis, which is a combination of Article 6, Paragraph 1, letter F on legitimate interests, and Article 9, letter 2I on serious cross-border threats to health. And this raises broader questions. This leads to the second problem, which is a question of necessity, really, and what we need about necessity. What about the legal basis? So if we keep aside for a moment the fact that the questionnaire as is not lawful, we have a question of whether, once the issues are corrected, it can still be used. And I'm going back to the guidance that the Data Protection Commission released back in March, saying that things like a questionnaire, for instance, would have to have strong justification based on necessity and proportionality and an assessment of risk. Something like this could be meaningfully justified based on specific organizational factors and directions or guidance of the public health authorities. Now, we all agree that COVID-19 is, of course, a threat that provides a strong justification, and that it would be proportionate to perhaps collect mobile information, something to be able to contact the person in case of and the need to conduct contact tracing. However, what about health data? And does hairdressing or barbers or salons fall into these organizations having specific or featuring factors that would justify the collection of this data? I really searched through the HSC website for the source of this checklist, but all I could find was that it originated from the NSA. So is this akin to, can we say the NSA is a public health authority, or that their guidance is guidance akin to that of a public health authority? It raises questions in general about the legitimate interest side of the legal basis as being a little bit of a catch-all. And I mean, I take what David was saying earlier about the desperation of needing, really needing to go to see a hairdresser after 3 months of lockdown. How many people who are not data protection specialists are going to refuse to fill in the form for the sake of protecting data protection and going around defying what's common social practices with their hair like a mop? I don't think this would be very many people. I take the point that control can be, consent can be tricky, but legitimate interest can also be tricky. Of course, when we remove consent from the equation, we are removing conversations about power imbalance. And I believe that there is a power imbalance here. And what we are seeing is a little bit of a disturbing, take it or leave it, online approach transposed into real life. The point that I am trying to make is that I believe that the debate needs to be broadened. It's good that we look at tech-based solutions, and that's what I'm also working on most of the time. But we don't want to end up in a situation in which we have the perfect voluntary app that no one or very few people download, as opposed to have mandatory data processing, which is defying 40 years of very painful development of data protection legislation, for the sake of correcting this power imbalance. I think that the comprehensive public health strategy to fight the pandemic has to try and cover both grounds. I know that this is a little bit of a challenge because governments at the moment and ministers are trying to do their best, but perhaps we need to have the conversation broadened. Thank you very much for your attention, and do follow us on the COVID-19 Law and Human Rights Observatory.
Thanks very much, Maria Grazia. We all knew that another NSA was a threat to our personal data, but now it seems that the NSAI may also be a threat. I'm going to pass over now to a man who may be able to provide us, if not with the answers, at least perhaps with some guidance which may help us all in getting to some of the answers to those difficult issues. Colum, the floor is yours.
Thank you, David, and I'm delighted to have the opportunity to join you today, but also to benefit from those insightful presentations from both Orla and Maria Grazia. In particular, that last point in relation to the NSAI, which I'm very happy to come back to as we go through. I think it illustrates the theme of what I'm going to try and speak about. And really over the next 10 minutes or so, I was going to share some of the experiences from the Data Protection Commission's perspective on the issues relating to data protection rights during the pandemic. And in doing so, I wanted to begin by providing you with some of the practical data protection issues that have arisen for data subjects, data controllers and public authorities as a direct result of the pandemic. Then what I wanted to do was go on and maybe just discuss, as the others have, just some of the, I suppose, how these practical examples are dealt with within the data protection legislative framework. By the end of the talk, what I hope is that you'll at least see themes emerging for the data protection challenges faced, and also, I suppose, some direction on how these can be met. As a final kind of opening remark, what I wanted to say was, it is important to note that a lot of what being said by data protection authorities and by the EDPB is really that GDPR principles don't present an obstacle to data processing activities designed to address the spread of the virus. The GDPR does not prohibit data processing activities, but instead permits them if certain principles are met. And it does that in order to respect individuals' integrity, dignity, and fundamental rights. And I think a lot of what we'll see through the course of hopefully what I talk about is around how those principles are in play and how they ought to be used. So to look at the practical data protection issues that have arisen and have been brought to our attention, including the new one around the NSAI today, I want to maybe go through, like a lot of what comes to us comes from individuals who raise concerns. It may be individual data controllers who come to us with a query, and then we have some more formal consultation and engagement. But to look at these, I suppose, keeping with the current language, what I was hoping to do was to break them into 3 phases. And the first phase really followed, I suppose, the declaration of the global pandemic, and at the time when we saw the gradual imposition of restrictions here in Ireland. So bringing us a long time back to March. And this phase really began to raise the discrete and novel issues around the processing of personal data, and in many cases, special category personal data. And so, for example, we began to see issues like controllers, usually employers, who wanted employees or visitors to the workplace to fill out questionnaires, some instances with detailed health information or with information about recent travel. We also began to see issues around dealing with a diagnosis in the workplace. An employee discovered that their diagnosis had been disclosed to their colleagues. We also saw in this phase consultation on some of the draft legislation underpinning the imposition of the restrictions. Now, very little of that had data processing contained in it, but there was some consultation with our office. And we also began to see the emergence of guidance around issues, particularly in the workplace. The second phase then related to the period where we moved into the restrictions, and the restrictions were in place. And in this phase, we saw, interestingly, issues around the security of data when people were working from home. We also began to see questions around the use of online platforms for meetings, conferences, seminars like today, and education. We also then began to see more questions around contact tracing and engagement on contact tracing, in particular the app. And whether that was the manual contact tracing or obviously the development of the app, but there was also issues around contact tracing for the arrival of overseas visitors and legislation underpinning that. And we also then saw around this time commencement of testing and the rolling out of results for testing. And one of the interesting issues that arose in that context, again, was the disclosure of information, special category personal data related to health, to employers. And then ultimately, we even saw issues about the leaving certificate and the extent to which the purposes for which continuous assessment material had been gathered, whether that was now compatible with the new purpose of giving a grade. So then we moved into the third phase, which is our current phase really, which is the reopening of the economy. And again, issues, some instances were coming back on the same issues, but the predominant issue has been around the return to work safely protocol and the openings of bars, restaurants and other businesses. And these two give rise to issues like contact tracing, medical questionnaires, and temperature testing was another factor that was introduced in the context of the protocol. We've also seen the finalisation of the DPIA for the contact tracing app. Our understanding, I don't know whether it's expected to be rolled out shortly. The DPIA and the source code is to be published by the HSE. I think it's already on their website. They've also included a document which sets out our observations on the DPIA. So they're available on the website and worth taking a look at. But I think what we'll see is as this phase goes on, other issues will pop up, because the reality is we will see issues emerge as the processes bed in. But what we've found over all of these phases is really that the guidance that we've had to provide to individuals or to data controllers, or the more general guidance that we provided on wider issues and engage with government departments and in industry, we've really found that in many ways what's happening is a lack of going back to first principles. And you know, so if you look at the even the example cited there by Maria Grazia, it is, you know, individuals I think who are motivated by good. They see that there's a public health issue. They want to protect employees or visitors to their premises. And I think what happens is that they somehow begin to take into their hands processes that they believe are useful and are beneficial. But they seem to forget to come back to the data protection principles that are associated with processing personal data. And so what we have seen is, whilst there may be an ability to find a legal basis, whether that be through Article 6 or Article 9, and some of the, I suppose, some of the bases that are being used at the moment, certainly being cited, are things like Article 6(1)(d) or E are being used. We also see Article 9(2)(i) in relation to public health measures and the reliance on Section 53 of the Data Protection Act. But often what we find is that there is a failure to look behind that and to begin to engage at the very first principles around data processing. And I think what we have ended up doing when we're engaging with controllers in particular is posing very, very basic questions. And these are ultimately about what is the purpose of the processing. What is the legitimate purpose that's aimed at to be achieved here? Is there another way to achieve that? Without actually an interference with data subjects' rights. What is the lawful basis being cited? And I suppose to echo the points made as well, if there is a lawful basis being cited, whether that's being used through Article 6 or Article 9, the issue then comes down, is the processing necessary and proportionate, having regard to the objective to be achieved? Also questions about how much data do you really need to gather? You know, we see even the example there cited in terms of that questionnaire. If I want to go back and I desperately need to go back and get a haircut, I think the information that's been requested there is certainly excessive. Also, how long do you need to retain it for? How will it be stored? Who will have access to it? And particularly where we looked at special category data, the things that arise is, do you really need, you know, have you obtained the consents if you're relying on Article 9? Are those consents valid? And particularly that creates issues in the context of an employment situation. I know that the DPIA and the app, the tracing app here in Ireland, is relying on consent as the lawful basis, and we've been very clear about the conditions that attach to such consent and to ensure that the HSE has regard to those. But in many of the examples that we've encountered, they're just basic questions were not asked, either by setting a particular policy or by those following it. And this has a risk to leading to so much confusion. And like, for example, after the protocol, the Back to Work Safely protocol was published, we received a number of queries about temperature testing. But the protocol says temperature testing on the advice of public health authorities. There's no advice to do that at the moment. So we've been engaging with the department and with the HSA, and clarification has been brought now in relation to that. But interestingly, I met a friend who runs a small business shortly after the protocol was launched, and she had spent €150 on buying thermometers to bring into her workplace. And you can see that, again, it's just the confusion where policy is set. It's not brought back to the first principles. It's not brought back to what are the purposes, what are we trying to achieve here? And the difficulty that emerges there is also the potential for creep in terms of the purposes. We find that other individuals, particularly, I think, as Maria Grazia has referred to, individuals who are probably not used to being in the data protection space as controllers, all of a sudden are using the information for other purposes, or may use it for other purposes. And we saw that, I think it was flagged in the UK last week, that one of the concerns around the return to, or the reopening of pubs and restaurants, and that requirement to have a contact tracing name could result in indirect marketing, etc. So it's very important that individuals who are put in this position of gathering information because of a public health requirement, for example, understand that that is the only purpose they can use it for, and they understand that the data must be deleted and kept safely. We've also seen it, as I said, with situations where the HSE, for example, were disclosing results from testing to employers. Now, here again, at a very basic principle, I think at the time everybody was taken aback by this and saying, well, this doesn't conform with basic patient confidentiality, let alone coming into data protection rights. And there's also a risk that the GDPR can become abused by this process because there's a danger that individuals will see the GDPR as being raised as barriers to stopping the spread of the virus. And our sense of it is that that's not correct, because the reality is, when you pull back to first principles, you look to ground the lawful basis, you apply those principles. I think there is generally a case where the activity will either not be justified, and I think that's reasonable, or it'll be justified and it's reasonable to carry it out. I think there are questions there, as Orla alluded to, in terms of big issues like necessity, and those are hard to provide guidance on. But the reality is, what you're saying to data controllers is that when you have regard to the purpose of what you're carrying out, that you do need to look and see, is this ultimately necessary to achieve that objective? So there's, I suppose, the other really interesting thing that has come to our attention as well throughout this is the fact that data subjects are much more aware of their rights. And as I say, a lot of the basis for which we would receive this information or these queries comes from individual data subjects, who I think become suspicious of processing and wonder whether this is excessive and whether it is necessary, and so they come to us with their queries. So I think that's a really important thing to see, is that individuals becoming aware of their rights and knowing to act on them. I think it's also important to acknowledge that many of the processes that have been put in place are urgent responses, and have been, for the most part, guided by, I think, genuine goodwill to achieve an important goal. And so what we have done is, where these issues have come to our attention, is we've been fortunate enough to engage with controllers, and often we've been able to bring around, through that positive engagement, a change on the advice, or the advice of the GBC. Changes have been brought about to bring the processing into line. I suppose I'm conscious of time. I think that the real headline, I think, for me certainly, is that the pandemic has changed an awful lot in some ways in our lives. It's also done it in terms of data protection law, particularly, seeing legal bases has now been engaged that we thought were always going to be academic, seeing those actually being used. But at the same time, I think a lot of what's happening comes back to basic data protection principles, and that really the starting blocks should be there, not only in the pandemic but outside of that. I think it's been useful, again, just even the example of the checklist. I've already emailed my colleagues to see. We've had no engagement on that, but it's something that we would be interested in bringing some clarity to, because I think, as rightly said, a lot of the information that's sought there is probably not necessary for the purposes of getting the haircut that I desperately need. Look, thank you for that. I know I've probably run over time, and it's a whistle-stop tour, but I'll be perfectly happy to take any questions that might clarify issues. Thanks.
Brilliant. Thanks so much, Colum. And I think across the presentations today, we see some familiar themes for data protection lawyers, because so often over the past 2 years and 4 years, the GDPR has been presented a little bit as a caricature, as this thing that blocks use of data for good and so on. Whereas in fact, as all of you have pointed out, and Colum has emphasized at the end, it's about thinking through the implications and going back to first principles in so many cases, including in this very novel context we find ourselves in. We have a few questions for the panelists. If anybody else has questions who's attending today, feel free to send them in now. I might start with a question from Mairead, which is for you, Colum. You mentioned the clarity on the temperature testing aspect of the protocol. Could you clarify what this is or where it is available?
So that is, I think, the Department of Enterprise has published additional guidance in relation to the protocol, setting out that at the moment there is no public health requirement for temperature testing. Equally, we've published guidance on Friday evening related to the data protection aspects, and that is provided there as well.
Brilliant. Thanks very much, Colum. Maria Grazia, Mary has a number of comments about the form, and she just, I think, is reflecting on her own experience in advising on these issues. We advise not to ask questions, but to ask people to declare that none of the above apply, and not to enter premises or return to work if they do apply. So we avoid collecting data other than through this declaration. Second point, she just notes that the DPC has issued more guidance, and I think Colum has talked to us about that. What do you think about that, Maria Grazia, as a maybe a more proportionate way to go about this?
I think that the question on the second point about the DPC, I'm aware of the guidance because I was looking through all of the guidance to try and make sense of the information available. I think on the specificity of the guidance, I'm just now retrieving the document itself. I don't understand if Maria is recommending to change the guidance in this way. So is this something
so
that
I think it was just more an observation, just to highlight the guidance. And I think the main issue was just this alternative of a declaration as opposed to questionnaire.
I think it would definitely be going in the right direction, though of course that raises the question of the necessity in the first place. When the first time I read this document, in fact it was quite funny because it was in the context of wanting to go to a hairdresser prior to this talk, because I thought it might have been nice to have to have a haircut. Yes. The point is that it sort of I was wondering what the reason was, whether it was actually for insurance purposes in the end of the day, whether it was a matter of the salon and the people working there to be not to be liable in case something happened. I was really wondering. So yes, I think that would go in the right direction. However, it raises the overall question of, if you answer yes to any of those, you can't even enter. So why collecting the data? So obviously you have to reply no to all of them. Yes, indeed, I see the point. Indeed, absolutely. So it sort of defies the purpose of the questionnaire in the first place. So we might want to discuss whether this is just going in the wrong direction. Thank you.
Very good. And Marie has just observed that you can achieve possibly the same purpose without necessarily collecting all the information, which is a very valid point.
Exactly, I agree.
Orla, on contact tracing apps, because obviously we've had our debate here, which Colum has alluded to, and there's been a lot more transparency and engagement, it appears. There's a question from Sinead. What about the fact that the COVID tracing app is appearing in the settings of Android phones, unknown to the owner, without consent or knowledge? And the second question from another participant, are there potential health insurance implications due to contact tracing, i.e. one may find that they are subject to a premium if they've had COVID-19 and so on? So some of the maybe medium to longer term implications of using the app.
Yeah, so maybe first of all with Sinead's question, I'm not aware of this issue. I haven't come across it at all. So, one thing to note is that each of the apps is being developed at national level. So although, across Europe or the European Union, there's kind of wide-scale consensus around the idea of a decentralized app, apart from in France, there are kind of specificities to each of those apps that are unique to those states. And to my knowledge, all of them are voluntary. So I can't see then how, unless it's on the initiative of Google, that there is kind of a pre-installation of an app. And if that were the case and the app was actually pre-installed and processing personal data, then I think it would lack a legal basis because there would be no kind of mandatory requirement in the law for that to happen. So that would be a fairly unusual situation, I would say. Maybe just also say that I think in this, and something I didn't mention in my presentation, is that this is really kind of raise some issues around the role of Google and Apple in kind of setting the technical parameters for states around the shape of the public policy response. And what I mean by that is that the Google and Apple API won't actually allow states to kind of operate a centralized processing app in a way that is compatible with their technical specifications. And so in essence here, you have two private companies dictating to a state what kind of shape its public health response takes. And there's certainly in the UK that caused some kind of consternation, because the argument was being made that a centralized server was needed in order to gain extra epidemiological information that would be necessary to help manage the outbreak. And in France, there's also been a lot of pushback against that, kind of arguing that this is an incursion into state sovereignty. Now, neither France nor the UK tried to kind of legislate to force Apple or Google to do otherwise, but you've seen this really interesting kind of power dynamic at play. But that's kind of the only issue I'm aware of around that, the operating systems themselves. And then on the insurance question, I think this is really interesting. If that contact tracing information was shared with insurers, I would then, kind of going back to first principles, say that if that wasn't initially set out in terms of the purpose specification, that would be processing the data for an incompatible purpose. You know, a separate question is, in the future, will we be asked when we're applying for insurance policies to indicate whether or not we've had COVID in the past? I would imagine so, and that will simply form part of the package of health information that an insurer will take into account when calculating a premium. But the use of the data from the app for those purposes would, I would say, breach purpose specification.
Super, thanks very much, Orla. And in fact, that brings us to the end of this session. Thanks to everybody for those questions, but thanks especially to our speakers today, Colum Walsh from the Data Protection Commissioner, Professor Orla Lynskey from the London School of Economics, and Maria Grazia Porcedda from our own law school here in Trinity. And thanks again to Professor Aileen Kavanagh, Professor Blondie Clark, and Stephen Britton, who were instrumental in organising this series. Thanks to you all for participating. I hope you found these seminars useful, and we wish you the best. Thanks very much, everybody. Goodbye.